Hi, this is Dr. Emily Sherwood. I am a veteran of almost 20 years working with English learners and a reading specialist as well. I now have my own small business in the education field. And so I'm going to be talking today about the rights in education of culturally and linguistically diverse students in the United States. In other words, children who are from cultural or linguistic backgrounds that vary from kind of what is the norm. Often these students are English learners as well. So I'm talking some about that. So I hope this is really helpful for you. You may hear a couple of just little things. You may hear my daughter in the background from time to time. I have a 6-month-old and she has to be held all the time. So you may hear some in the background and I apologize about that. It's just the way it is. And I also am doing some translations of this. And I apologize in advance if the translations are not the greatest. I'm just one person, don't have unlimited time or money. So the translations are just what I'm able to do with what I have using technology. So let's get started. Okay, so I'm going to begin by saying that the United States is a country based on rights. Many countries, particularly those in Asia, sometimes in Africa, and sometimes in Latin America. Latin America is kind of a mix. But the governments of those countries are based more on what's right for the country and what's right for society at large. But the United States is not like that. The United States is very individualistic. That means that the United States focuses on the individual, probably the most individualistic country in the world. So in the United States, the government, as well, largely a society, is very rights-based. So the idea of rights in education, especially when it comes to culturally and linguistically diverse students, is actually pretty complex. There's a lot to learn. So to help with this, I have divided these rights into 3 categories for the purpose of this video. The first is the right to go to school, the second is the right to equal treatment, and the third is the right to extra services if needed. Especially if needed for language. So the first right is the right simply to go to school. In the United States, every child can go to school, and that does not matter your nationality, your legal status. If you have a disability, it does not matter. You have the right to go to public school. So in 1982, the year that I was born, there was a case called Plyer versus Doe, and that case decided that children in the United States can go to school even if they do not have documented status, permanent residency, or citizenship. So what that means is if you have a child and that child, for whatever reason, does not have a valid visa or green card or was not born in this country, it doesn't matter. Your child can go to school. And there are privacy rights that forbid the school from communicating with ICE. Or any kind of immigration authorities without a warrant, which so far has not happened. It's pretty much standard that schools do not communicate with this, with other agencies. They can get in really big trouble if they do that. And I also want to clear up something because there are some school districts. There was one in Alabama a few years ago, and now there's one in Oklahoma that are trying to determine if students are here with paperwork documented or not. That is an intimidation tactic because those states cannot turn over names to ICE. There's a privacy issue with that, and they just can't do it because there's educational privacy, and I'll talk about that a little bit later in the video. So they will never turn over names to ICE. What those states do is they will determine, and again, they can't really decide. A parent can lie, a parent can just say, I don't want to talk about this, but somebody in that office will decide if they think that student is documented or not, and they will send numbers to the state. And they say that they're doing this for data reasons. In other words, just to know how many students are in the country. There's no reason for that. There's no reason at all for them to know that. They have all the data they need as far as students who are language learners, students who are of different ethnicities. They have all that data already. That's a scare tactic. They want to scare you into not sending your children to school. You have nothing to be afraid of on that end, because as of right now, and things could change, but as of right now, immigration does not get involved with schools, period. Only time that immigration could get involved is, again, if they have a sign for it. And so far, that has not happened, even with this new immigration crackdown. So schools can and do ask for proof of identity. And in most schools, this is required. I've never worked in a school where this is not required. What that means is basically the schools are looking for the student's birth date to verify what grade the student should be in, and that that the student is of school age. So usually a birth certificate is what most people use for verification of identity, and that can be from a different country. That's not a problem at all. Some other forms of identity are also a passport that has the student's birth date, and also if the parent has a transcript. What a transcript is it's a record of the courses a student took in another school. Records those can be used for proof of identity also. So schools also ask for proof of residency, and what that means is that you live in that school district. So in the United States, we have school zones. And so what that means is every home, every neighborhood or every home has a school that the child that is in that home is assigned to. And generally you go to that school. And now we do have some things called choice schools in the United States, and we have charters and we have vouchers, and that's a whole other thing. But for parents who are new to the country, I would just suggest to go to the neighborhood school to start with. And that's what most schools are. There are very, very few of these choice schools or charter schools or vouchers. So anyway, in these neighborhood schools, whoever is in the office, the secretary, usually, sometimes a principal or another person will check and make sure that this is the school the child is assigned to. And that's partly because of taxes. Tax money goes to neighborhood schools. So schools don't want children going to their school if they're not assigned to there, and the parent isn't paying both taxes in some form, even if that means just going to the store and buying things. If you go to buy things, then your tax money will go towards the school. So schools vote for children to be within their assigned zone. So to do that, you can if parents have a license, they can use that, or family members, if the guardian of the child. Generally, they will ask for a license, but it doesn't have to be a license. And that's one thing that some people don't understand. It doesn't have to be a driver's license. There are people who are citizens of the United States who don't drive and don't have licenses. It can also be something like a bill that has the parent or the guardian's name on it and the current address. If none of that is available, sometimes schools will ask for affidavits, which is where the parent has to go before a judge or a notary. It's usually a notary, which is just someone who is licensed to take information and make it legal, and say, I promise that I live at this address. So every state in the country has different vaccine requirements for school. And sometimes the requirements are different based on age. For example, I know here in South Carolina, students are required to get the hepatitis shot, I believe, in the 7th grade. So it depends on the student's age, and it also depends on what state the student is in. Vaccines are generally required for everyone. There are what we call exceptions, which means that for some reason the student doesn't have to have the vaccines. I believe every state has a medical exception. So, for example, if the child has had a heart transplant, I have a relative who had a heart transplant as a child, and he cannot get vaccines because his immune system is weak and he just can't get them. There's almost always a medical exception. In fact, I believe every state has it. There are also, in some states, religious exceptions where if the faith requires that the child does not get a vaccine, the child doesn't have to get it. And in some states, there's what's called philosophical exceptions, which is basically the parents don't want vaccines. They don't believe in it. In all of these cases, the parent can't just say, I don't want to do this. The parent has to fill out a form, and I'm pretty sure other people have to sign it, like a doctor or a pastor if it's a religious exception. Those rules really, really vary by state. The schools that I've worked with will generally take vaccine records from other countries. And also, in most cases, they will give some time for the vaccine. So let's say you are from the family is from a country that didn't require say the hepatitis vaccine. I don't think that's required many places in the world. If that child comes to school to register and does not have that vaccine, generally the school will give some time, 30 or 60 days, to get the vaccine. This is also done for students who were born in this country. If the child doesn't have the vaccine, usually schools will go ahead and enroll them, but they will give them a time period where they have to get the vaccines. Vaccines are available for free at almost every health department in the United States. And if a parent doesn't understand where to get the vaccine, that parent should ask someone in the office, a secretary or a principal, and the school should provide guidance of where that child can get the vaccine. So I also wanted to talk a little about the McKitty-Victo Act of 1987, and you might hear this called the Homeless Students Act also, because many families, particularly immigrant families, qualify for this and they're not aware. And sometimes school staff's not aware also, unfortunately. So this is an act that deals with students who are considered homeless. And the reason why I want to talk about this is because the definition of homeless is actually very, very broad. When most people in this country think about homeless, they think about somebody who may be living in a car or a campground or a shelter. But under this law, it's much more than that. So children are considered homeless if there's no permanent place of residence because of economic reasons. And that can include living with family members. So, for example, if a family comes to the United States from another country and maybe the family's just starting out and the family is living with relatives just for a short time, no matter how much money that family earns, that's considered homeless. So many students are considered homeless that would not be considered thought of homeless generally based on society standards. So if a student is in a situation that's considered homeless, then the student does not need identification and also does not need a vaccine record to start school. Now, that doesn't mean that the student can just go throughout school and never get these things. What it means is that the student can start. And in the cases where the student is homeless, someone at the school, if the school has a social worker, it might be that person, or it may be someone from the district, the homeless liaison. And if you're listening to this and you are a school staff member and you don't know who that is, it's usually the person in charge of federal programs at your district, or that person would at least know. So that's who I would reach out to first, is the director of federal programs or someone in that office. And the homeless liaison will help the student to get these things, particularly to get vaccines and to have some form of proof of identification from the home country, if that's possible, or if it is an immigrant student, or it may help them to get an affidavit. But it doesn't mean that these students never have these things that other students need. So if this happens, again, contact someone at central office. If you don't know who that person is, contact the person in charge of federal programs because they would at least know. Schools have actually gotten into trouble for not identifying homeless students enough. I know here in South Carolina, a large school system was sued because there were many, many students who could be identified as homeless and were not, and this is a civil rights issue. So schools really want to identify these students if they qualify. There's also money involved with this. There is extra funding. Again, this could change. But right now, there's quite a bit of extra funding for homeless students, and schools oftentimes don't use all of that, and they want to use it. So there may be money for things like tutoring or school supplies for these students. And then another benefit is transportation. So if something happens and the student has to change schools because of the economic situation, let's say a student moves from one family member's house to another with a family, then if the student wishes, the school will provide transportation to the original school. If the student likes that school and wants to stay at that school, the school will help them to be able to continue going to that school, either through, it may not be a bus, it may be something like taxis, or it may be a transportation card, or it may be a gas card. But there are benefits to having this identification of homeless. So it can really help some families. And again, because of school privacy rights, this is something that's kept confidential. That means no one knows, that doesn't need to know at the school. Only certain school personnel who are working with the student know. They do not tell other people. So public neighborhood schools are always free. What that means is there's no tuition charge. This can get confusing because there are students who pay to go to public schools. But generally, those are students who decide to go to a school outside of their school zone. So usually it's like the school district, the next county over. The school district there may charge because, again, that child is not in the school zone. And the family, the family is not likely to contribute in the form of sales tax or other taxes. Now, many schools, especially in the South, will charge extra fees for things that are not required. And the big thing here is technology fees. Most schools today will give students computers. They call that one-to-one schools, one device for each student. And there's a little fee. Usually it's between $10 and $30 a year for those computers. And if a parent does not pay that fee, the child will not get a computer. Now, the child can still go to school. The child can always go to school, but life will be very difficult for that child if that child does not have a computer. Another example are field trips. Field trips are where the class goes somewhere for the day. For example, it might be a museum, or sometimes they take students to sporting events, or to award ceremonies that may be in another place. Field trips sometimes cost extra. There's usually a fee involved. The same thing with athletic sports teams. Sometimes they charge for things like uniforms. These are all extra things. The child doesn't have to go with the field trip. The child can stay at school, and the child is not punished for not paying that fee. Now, this can get kind of costly, especially for parents who have limited funds. If you're a parent, I suggest asking your school if there is a fund to help for this if you are not able to afford these things. Many times schools have extra money in money from the government, or they have people who want to give to schools. That's pretty common. There are churches who want to give to schools. There are people who are wealthy who want to give to schools and to children. And so many times the schools can help find that money so your child can still have those extra things. So the next category of rights I'm going to talk about is the right to equal treatment. And what that means is that every child in schools has the right to be treated equally. In other words, students cannot be discriminated against because of things like gender, if they're boys or girls, ethnicity, where the child is from, the child's family background, or religion, anything like that. The child cannot be discriminated against. Disability is a big one. Cannot discriminate against people with disabilities in schools. So this category is what I'm talking about next. So English learners or students learning English must be placed age appropriately. So what that means is students learning English must be placed in grades and classrooms with peers, other children who are of similar age. So many times in schools, when a child comes, especially if a child is a beginner student, just learning English, either the school staff or sometimes even parents will want to put that child in a lower grade to give that child some more time to learn English and maybe catch up with some academic skills. And that's done with the best of intentions. That's out of compassion and wanting the child to succeed. However, that is not allowed by the law. And when I tell people this, they have a real problem with it many times. They're just shocked. Because why wouldn't you want a child to have more time? But that is a very American and middle class view. Many families do not have the luxury of keeping children in school longer than needed. So for every year that child is in school longer than needed, the rate of dropping out increases dramatically, like 50% higher if a student is not placed age appropriately. Because at some point, it's more likely that student will have a problem that causes them to have to leave school early. For example, that student may need to work to make money for the family, or that student may need to care for someone in the family. That student may become a parent. Yeah, I mean, it does happen to students of all backgrounds, and have to drop out. If that child is placed age appropriately and does not have to stay that extra year or more, then it's much more likely that student's going to graduate. So that's why that law is in effect, that policy is in effect. And it's pretty strict. Usually you have to document if a child's not placed age appropriately and say why. Or if not, it can become a civil rights violation, which no one wants at their schools. All students in the United States have the right to what is called educational privacy. A lot of times school staff will talk about FERPA when they talk about this. FERPA is the law that covers this, and it's Federal Educational Records and Privacy Act, FERPA. And so what this law says is that as much as possible, teachers cannot share information with people other than parents and students. So, for example, a student's grades. The student's grades cannot be shared with others. I know in some countries they post grades, like on the door. They post the student's grades. You cannot do that here in the United States. You cannot share how a student is doing with other people other than the parents and the student. Also, things like test scores cannot be shared. Things like information about a student's disability or health background or discipline issues cannot be shared. All of that is covered under FERPA. So this is why the school cannot communicate with ICE without a signed warrant, because of this Educational Privacy Act. So this is important for parents to understand, because in many cultures this doesn't happen. If a parent votes someone outside of the school to have this information for some reason, like another family member, there might be another family member who needs this information because they have to care for the child, or the child may be seeing a doctor who needs some information. The parent can give permission, can request for the school to send that information to that person, or they can get the information themselves and share it with the person. But that's the only way the school can give information out. So students must have access to the curriculum no matter what is their language or academic background or cultural background. So what this means is that all students are able to do all things that other students are able to do at school, if they qualify. So, for example, a sports team cannot say, well, I'm not going to have that person on my team because they don't speak English well yet. That can't be the reason why the person's not on the sports team. If the student tries out and doesn't make the sports team because the student didn't have the skills, and there were other students who weren't English learners who didn't make the team, then that's acceptable. But it cannot be because the student doesn't speak English. Same thing with art and music classes. The student has the right to take those classes if the student qualifies for them. And foreign language. Unfortunately, sometimes students are discouraged from taking foreign language because they're language learners. And that is inappropriate. Students should be able to take foreign language if it's open to all students, or if the student meets the criteria that the school has. Now, unfortunately, because many of our ESOL programs are what we call pull out, and I'm going to talk about this later in this video, but students are pulled out from class to do these programs. Students do sometimes miss things like art and music because they don't want for students to miss regular part of the class day. This is a problem that has not been solved yet. Some classes have intervention blocks. Some schools have intervention blocks, and that's the best way to solve it, where every student in the school gets either intervention or enrichment. That's the best way to do it. But logistically, it's very difficult. So this is not something that's truly practiced in a lot of schools yet. There are still students who are not able to take the things that they want to take because of getting help with English or with other things like intervention programs and special education, because those often take place during electives where students get to choose what they like. But as much as possible, students must have access to the curriculum. So if a student is going at a time and the parent does not like it, I encourage that parent to talk to the school and see what can be done, because students, as much as possible, should be able to take the classes they want and do the activities they want. So students also have rights to reasonable cultural and religious accommodations. So what that means, if a student's religion requires something, the school makes a plan to allow it as long as it doesn't interfere with other students or with the functioning of the school. So, for example, some of the big ones are that some students pray, several times a day. It's part of their religion. The school should provide a place for students to do that. It could be a small place. It could be, something very small, but a reasonable accommodation would be to provide a private place for that. Because obviously it would disturb the whole class if the students did it in the class. That would be unreasonable. That would not be a reasonable thing to do if the student is praying out loud while the teacher's teaching. But the student can go to a more private place and pray. Other biggie is food. Many religions allow pork, for example, and some don't allow beef in that religion. And so the cafeterias of the school have to provide a different meal for those students on days when that is offered. And that's required by law. Now, sometimes people don't understand that, particularly people in the cafeteria don't understand that. They may not have received training. And in that case, the parent needs to go to the principal, usually to the principal, and if that is a word, go to somebody's central office, because the schools, that's a reasonable accommodation that the school can provide a different meal just for that one child. There's usually lots of different food that the school can provide and do it pretty easily. Now, what's unreasonable is what someone voted in Tennessee, where I used to live. Someone at a school district voted the school to totally ban all pork. He didn't vote the school to offer pork at all. That didn't happen because that's unreasonable. The school already has its menu. It already has the food that it's planned and people who are sending the school the food. So that's unreasonable if the parent expects the school to do it for every child. But it's reasonable to do for one child. Again, that's something that's pretty easy for the school. And it honors the child's religion and culture. Some other things are things like religious holidays. So if there is school on a religious holiday, obviously the school can't fit in the calendar all the religious holidays in the world. There are lots of different religions. That child is excused for school for that day, and it cannot account against that child. So, and that is reasonable because, again, most of the students go to school just fine, and it's not a problem for the other students. So schools are usually pretty good about this, but sometimes they have education. And so that's why I say if this becomes a problem, go to the principal. And if the principal doesn't understand, you can go to someone at central office, usually the person in charge of civil rights. And if you go to the school's webpage, or the school system's webpage, they will always have that person listed. A part of equal treatment is also equal communication. So what this means is that anything that parents get in English, so the United States is one of the few countries where by law, students who need help, extra help for a variety of reasons, must receive that help. And that's something the United States is very proud of. Because most countries do not offer extra help for students by law or by policy. Sometimes it still happens, but it's very rare that there's a system to help many students who need it. So more than anything else that I talk about in this video, this section has information that's most likely to change as things are changing very rapidly nationally in the United States right now. So I'm making this video in February 2025. So if you're watching this and it's 2026 or later, or even later in 2025, you might want to check what I've said to see if it's still in place. So most English language programs started with Law versus Nichols in 1974. And this was a court case that ruled that language learners had to have supplemental services to help them to learn English so that they could achieve in school and do better in life. It wasn't enough that the students could go to the same school as other children and have the same books and the same resources that children who are from other language backgrounds needed to have help to acquire English. So that's when most English as a second language or ES or English or speakers of other languages. There are lots of different names, but that's when most services began. So one thing I got asked a lot when I was in U.S. public schools was, why is that student in your class? That student speaks really good English. So I'm going to talk a little bit about how these students are identified and the process with that, who becomes an English learner. So The process starts with what's called a home language survey, or HLS. And every parent, no matter what family it is, even if it's a family who has been in this country for generations, since the beginning of time, colonial periods, by law, every family is supposed to complete this form. And have the form in the child's permanent records in case that child changes schools. The HLS is available on most state websites in multiple languages if there is a family that speaks a different language. But it's very, very important that all families get this form, because there are children who really need services who just fall through the cracks because this was never given to them. Something happens. Maybe they changed schools and never got one from the new school, or they just never turned it in. But it is the responsibility of every school to ensure that all children have this form called the HLS. And the questions are a little different depending on the state, but basically it asks it asks 3 questions. Sometimes there are 4, and it asks about what language the child speaks at home, what language the child speaks outside of school, and what was the first language the child learned. Now, the wording on this makes it kind of interesting. If there's anything other than just English, that child has to be tested to see if that child qualifies for English learning. So that can mean that there is English and Spanish, for example, or English and Chinese, or it could just be Chinese, or it could be Creole. It doesn't matter what language it is, as long as it's not just English. Now, the form and the law do not care about a child's background. Or the child's family. All they care about is the language background. So this leads to some interesting situations. For example, some parents adopt children when they're 6, 8, 10 months old, and they might have been born in another country where that language is spoken. So they may put the language that the child spoke, when they were very, very young, that the child learned. Children learn things when they're babies. But if that child came to the United States at 10 months and only had English-speaking parents, it's very unlikely that that child would need English services because of not speaking English, or not having academic language or reading skills in English. But that child still must be tested. I've seen it before where there's a student who really likes Spanish. She wanted to be an interpreter as she got older, and so she had many friends that were Latino. I think her boyfriend was Latino. So she answered one of the questions. This was a high school student, I think 15. She answered one of the questions Spanish, and the school had to screen her. They had to give a test. The law was very, very strict about this, and parents are not supposed to be allowed to change their answers. So there's no way around this. It's the only program I know of in education where parents do not have the right to opt out of initial testing, and that's just the way it is. So that's how students get identified. The next step is for the student to take a screener, and it's sometimes also called a placement test. And in every state in the country, by law, the placement test or the screener has to include testing for listening, speaking, reading, and writing, because those are considered the 4 domains or the 4 parts of language. So the student has to take this test, and based on the test, the whoever's giving the test, the teacher that's giving the test, will come up with a score based on the student's responses, and based on that score, will determine if the child qualifies for English language services or not, and if so, about what kind of help the child may need. I want to go over 2 common practices that come with identification of English learners and their instruction. The first is waivers. So parents do have the right to waive services. What that means is if the parent does not want the child to be in English learner services, the parent has the right to say, I don't want my child to have this extra help. Now, the child is still considered an English learner. That's in the computer, and it can't be changed. And the child still has to take the proficiency test, which I'm going to talk about in a minute. But so even if a child's parents do not want the child at instruction, the parents have those rights, but the child still, again, is identified as a language learner, still receives accommodations, which I'm going to talk about in a bit. Those are things to help the child to succeed in school, and still has to take the test. Other concept is clustering. And this is done a lot in certain geographic areas, like it was done a lot in Tennessee, particularly East Tennessee, where students may be really spread out. For example, there might be one or two students at a school who qualify for English services. So clustering is idea of all the students who need English services or who need a high level of English services, students who may be beginners, all go to a particular school. And so this is done again in places where there may just be, a few students in a school who qualify for English learner services. There's not enough to have a teacher there most of the day. So with clustering, the students might take a bus and go to a different school. And this is a practice that's in South Carolina, it's not done hardly at all, but in Tennessee, it's very common. So it depends on the area that you are in, that clustering is done or not. So all English instruction must be based on a model that's based on research. That means a way of teaching that is proven to work for students learning English. So the most common are pull-out, which is where students leave their regular classroom for part of the day or several times a week to work with an ESOL teacher. Push-in or inclusion, where an ESOL teacher comes inside the class and may help students within the class and also may do some of the co-teaching. And then there is a class period where students will take a ESOL class for credit. This usually happens in middle or high school. And sometimes, depending on the district's policies, students may earn credit towards graduation with these classes. It may be an elective or it may be an English credit. Now, those are the most common. But there are other models, particularly bilingual education, which is where students learn in two languages. And within that model, there are lots of different models. Sometimes students will learn with native English speakers who are learning the English learners' home language. Sometimes they'll be all English learners who are gradually moving from instruction in the home language to English. There are many, many models for that. There's also something called sheltered English, where a student will be in a class with other English learners and will be learning material, usually content, such as social studies or science. And kind of connected to that is something called SIFE classes, Students for Interrupted Formal Education. And those are students who may be lacking basic skills, trying to get those students to catch up some so that they can graduate from high school. So there are many, many, many models, and it just kind of depends on what's going on with the student. Another model that actually is used very widely is called consultative or consulted services. And that's when the student is very high in English ability, but just hasn't passed the test yet. And, those students will be monitored, and they will also receive kind of advising services periodically as well. So every student who's identified as an English learner has to take the language proficiency test each year. It's usually done in the spring. And this test measures listening, speaking, reading, and writing. And there's absolutely no waiver for this test. Even if the child has a waiver for instruction, the child must still take the test. Now, I am not super familiar with some of the tests, particularly there's one in New York. There's one, I believe, in Texas. In some of these states that have larger populations, they have different tests. And I believe Tennessee is going to a different test now. I'm not very familiar with that test. But 41 states use what's called WIDA. It doesn't really stand for anything. It's just a language test. And WIDA is extremely extensive. What I mean by that is that it can take up to 2-3 hours for each part of the test, and there are 4 parts. I've actually seen students spend half a day on one part of the test, and it is an untimed test. So there's usually a window. For WIDA, there's always a pretty long window. It's usually 6 to 8 weeks, depending on the state. And so students will test sometime during that period. So there's really no way for parents to opt out of this. During state tests like state reading, state math tests, there's a big movement of parents who just keep their kids home on that day, but there's really no way to do that because the test lasts between 6 and 8 weeks. And the child's going to have to take the test. The test is also very it's just very grueling for students to have to take this long a test, as you might imagine, especially younger students, but any students of any age. And the students generally they miss ESOL during this entire time because the teacher's giving the tests. And if the student's not testing at that time, they will be in the gym or with another teacher. They won't be learning. They won't have any instruction with reading or writing or language during that time. And they might also miss other classes and other events because they're taking the tests. So a lot of people, myself included, are really critical of this test. I want to also mention that there's a test for students with severe disabilities called the alternate access test. So even students who have really severe disabilities to the point where, students who are nonverbal, who are not mobile, who can't move around at all, even to write, they have a test. So yeah, this is just a lot for students. And the exit criteria, because the test is so hard, many of the native English students who speak English as their first language, could not pass the reading and the writing part of the test. And students take this in addition to all their other tests. So this is an extra test for English learners. So you begin to understand why there is criticism of this test, with its length, with its difficulty to be exit. So that's another reason why students who may seemingly have good English skills are still in ESOL, because they can't pass the test. South Carolina and many other states are lowering their exit criteria. So for example, the WIDA has a scale of 1 to 6 for the score, and it used to be that you needed, I think it was a 4.5 composite. I can't remember the details. I only worked in public schools here 1 year, but now it's 4.0. So yeah, the students only have to have about 70% of the tests, between 60 and 70% of the tests correct to pass, to exit. So that tells you just what a difficult test it is. So yeah, that's the English proficiency test. So some states have required individualized language plans. In South Carolina, it's called ILAP, Individualized Language Acquisition Plans. In other states, I believe it's called ILP, Individualized Language Plans. And so these are plans that have accommodations for students. What that means is it gives students extra things to help them succeed in school. And it also has things like the model the program that the student's using, is it pull out, is it class period? It has information about the student's levels for teachers, things like that. But its main thing is the accommodations. So almost every ILAP has extra time mentioned on a test. For example, the student may get time and a half or double time to take a test. There may be extra time for assignments. There may be some things read aloud on tests, depending on the state and what is acceptable, what's allowed. And then there may be more extensive things, like if the student's a beginner, the student may actually have a different grading scale for a short time until that student can access English. So just like those of you who work, if you work in special ed or know anything about special education, you will know that students with disabilities have IEPs, which are very similar. And the ILAP is similar to an IEP. So it is legally binding. What that means is that schools can get in trouble if they do not follow these. So with the ILAP, the ways that schools generally get in trouble is if the child fails. That's, at this point in history, that's what schools get in trouble for. If students fail because the teachers are not doing the accommodations. So many schools, especially ones that have low levels of English students where maybe the teachers don't have training, they're actually just passing students' own because the teachers are not following the ILAPs. That's something that's unfortunately pretty common. I'm hoping that soon there will be more resources to help teachers with this and to train them on what ILAPs are. But for now, that's kind of how it works. So the ILAP gives information and accommodations for students. So I'm going to switch and talk about other programs and practices and English language students. So one practice that is still pretty common in the United States that's not always found in other countries is what we call grade retention. And about 7% of students go through this overall, not just English learners, but students in the United States in general are affected by this. So grade retention is the idea that the student needs more time in that grade, and so the student repeats the grade. You'll also hear words like repeaters, that student's repeating or that student's a repeater. You may hear teachers say, we're going to hold this student back. This is done a lot at the lower grades, particularly, and it's done a lot with children who are considered immature or unprepared to go to school. So in the United States, the lower grades are more stringent. They're more difficult than in a lot of places. For example, I know in Scandinavia and parts of Asia both that students don't really start learning how to read till about age 7. And here students learn at age 5 in kindergarten. So that's a very common practice. In older grades, sometimes students will fail courses and the teachers will make them repeat the courses. In high school, students may just fail one course. For example, they may fail a math course and have to take that course over or do what's called credit recovery, which is where students will work usually on a computer and do the course again so that they can get that credit. The law says that English learners cannot be failed based on language. So if a child fails, it cannot just be because that child is a language learner. Now, some schools and some districts have taken this to mean the child cannot fail, period. That is not true. What it means is that you have to have evidence that the child is not failing simply because of language or simply because of the not having background knowledge or not having a strong academic foundation, which often happens with students who immigrate from other places. They may not have basic skills that students here are expected to have. For example, if a student doesn't turn anything in all year, that student can be failed because obviously that's not language. The student's not making an effort, then that's not language. So legally, there has to be documentation that it's not just language, that there's other reasons that are valid. The reason behind this is for two things. First of all, it's a fairness issue. It's not considered fair to students to hold them back when there's something going on that's not their fault. The second reason is the same reason why students must be placed age appropriately, because being held back or repeating a grade leads to a much higher dropout rate. So schools are really discouraged from doing this. Because it really does put the student at risk of not graduating. So again, a student can fail, a student can repeat a grade or be held back, but it should be very, very rare, and it should be based on valid reasons that are not just language. So in the United States, it's also very common for students to be part of the special education program. And the special education program is for students with disabilities. So the last program I'm going to talk about is migrant education. So migrant students are students who have had to move within 3 years for the parents' work and whose parents work in agriculture or in food processing. So usually the children of farmers, the children of people who might work in meat packaging plants or chicken plants. Migrants do not have to be immigrants, and they don't have to speak a different language. There are lots of migrants who come from white or African-American families who speak English as a native language. And in South Carolina, there's something like twice as many migrant students as there are English learner students. And not all English learner students are migrant as well. Students' parents have a variety of jobs. So the way that students are identified for migrant services is through the occupational survey. And this is a form that's given when a child enrolls in school. And it asks about the parents' work and the family's history of moving. And if a child qualifies, a person usually at the central office who works with migrants will handle the paperwork and send it to the state migrant agency. And they pretty much take it from there. So teachers really don't get involved with migrants very much. As far as the migrant program, many times teachers don't even know that a student's migrant because, again, there's privacy, and that's not something that is hidden from teachers, but unless the teacher needs to know, they usually don't look into that. Migrant programs don't really affect a child's school day or school education, what they do is they give the child extra resources. So, for example, migrants are automatically receive free lunch, free meals at school. Migrants will often have access to tutoring programs outside of school. Depending on the state, there may be a credit recovery program, especially for migrants, because they do move so much. There may be a way for migrants to make up their coursework quicker and in a more easier way that may include using the home language. Sometimes there's summer programs for migrants. So migrants is just extra help, but it doesn't really affect a child during the school day. And again, this is only affects some of the English learners, and it affects students who are not English learners as well. So that's all for this video. I hope this was helpful for you. And thank you for joining me and Ellie, my co-host, my infant daughter.